What are the legal challenges to affirmative action from the Supreme Court? Imagine fighting for equal opportunity and then facing a court that questions whether race should even be part of the process. That's what has happened with affirmative action. The Supreme Court has made several key rulings that challenge race-conscious policies in higher education. These legal battles are about how institutions can or cannot consider race to promote diversity and fairness. The first major case was in 1978, called Regents of the University of California versus Allen Bakke. Bakke was a white student rejected twice from a medical school. He argued that the school was unfair because it admitted minority students with lower grades. The court decided 5-2 for that, using strict racial quotas was unconstitutional. Justice Lewis Powell said that quotas were odious to a free people. But the court also said universities could consider race as one factor among many in admissions. They just couldn't set specific numerical goals. For about 25 years after Bakke, the court allowed some race-based decisions. In 1996, in the case of Grutter versus Bollinger, the court upheld the idea that race could be one part of a holistic review process. This meant schools could look at race as one factor, but not as the only one. Then, in June of 2023, the court took a big step back. In the cases Students for Fair Admissions versus Harvard College and the University of North Carolina, the court's conservative majority ruled that race-based admissions violated the 14th Amendment's Equal Protection Clause. Chief Justice John Roberts, writing for the majority, said that admissions should focus on the individual, not race. He argued that the racial categories used by the schools were too broad or arbitrary. The court wanted a very clear and measurable reason for using race, which it said was missing. Justice Sonia Sotomayor dissented, saying this decision was a step backward. She argued that race-conscious policies are still needed to fix ongoing inequalities faced by Black Americans and other communities of color. These legal challenges are especially important for Black Americans. Affirmative action policies came from the civil rights movement to help undo centuries of slavery, segregation, and discrimination. They aim to give Black Americans better access to higher education and opportunities. When the court rules against these policies, it makes it harder for universities to use race as a factor to increase diversity. This comes at a time when Black Americans still face gaps in education, wealth, and job opportunities. Opponents of affirmative action argue that these policies hurt white applicants and violate equality. But supporters say that race-based decisions are necessary to address the lasting effects of racial discrimination. The court's interpretation of the 14th Amendment now treats race-conscious admissions as problematic rather than a way to correct inequality. This shift reflects a debate about whether the law should focus on individual rights or acknowledge the ongoing impact of systemic racism. In the end, these legal challenges show how complex and controversial the fight for fair access remains. They highlight the ongoing struggle to balance equality, justice, and the role of race in shaping American society.